requesting airport transfer and special service authorities within Clark County, Nevada, to operate a fleet size of 102 vehicles. The ownership of Paradise Transportation Company is wholly owned. It's a wholly owned subsidiary of Vegas Loop Operating Company, LLC. And Vegas Loop is a wholly owned subsidiary of The Boring Company, a privately held company owned by billionaire Elon Musk. The staff supports this application. The summary of procedures performed, there were two PLTIs filed on December 5th, 2024. Both were denied on January 30th, 2025. A background investigation was performed. Commissioner R. David Groover, serving in his capacity as hearing officer in this matter, took judicial notice of Elon Musk as owner of The Boring Company, a Delaware corporation and parent company to Vegas Loop Operating Company, the sole member of Paradise Transportation Company. The market, they had sufficient market in order to meet the application process and the NTA's requirements. Staff spoke with Ed Finger, Chief Strategy Officer of the LVCVA. He stated he was in support of their application. Staff is relying on Mr. Finger's testimony as verified market. The applicant's partnership with the LVCVA gives them great access to conventioneers. The LVCVA reported there was a monthly average of 512,000 conventioneers between January and September of 2024. Only applicants' vehicles will be allowed to load and unload at the stations and drive in the tunnels. No passengers. Hold on, sorry, lost my spot. No passengers pay for fares through a QR code and will continue to do so. And now passengers, pay for fares through QR codes and will continue to do so until such time as Paradise separate app is functional. They met all financial requirements for their pro forma balance sheet and pro forma income statement. There is a cash infusion required. And staff has verified that funds are available. And that is the summary that I have.
Thank you. And Commissioner, any questions? No. So I'll go ahead and turn it to a comment related to the application from the interested parties. Go ahead.
Brian Hardy with the law firm of Marquis Arbach. I'm here concerned regarding the abstention issue, in particular because I believe it taints this proceeding. One of the things that we hold underneath the Karkanian case is that individuals on boards and commissions should be voting anytime so long as they can make that disclosure and they're not unduly prejudiced. In this particular case, the issue before this commission is the issue of this particular application. As noted in staff report, the PLTIs have already been denied. Therefore, there is only one other party to this particular proceeding, which is the applicant themselves. The right of individuals to petition their public officials is ingrained within the First Amendment to the United States Constitution and that of the Constitution in the state of Nevada. This issue has actually recently been addressed even by the state bar when there was an attorney who was able to go petition the chair of a commission on an issue that was actually litigated by that attorney. And it was determined that because there was no quorum that was formed, but he was actually able to do that, there was no ex parte communications. That issue has been affirmed and is by the district court and is now headed to the Supreme Court because the state bar is challenging that. So I'll disclose that particular issue. But the right to petition your elected officials stands ingrained under the Supremacy Clause of the United States Constitution. It overrules any particular laws, regulations, or statutes that we have here today. So I believe that disclosure is important. And I think Commissioner Zoka did an appropriate thing today. He disclosed, but he did not abstain because he was able to proceed forward. The problem I have is that I believe the chair should have been able to continue forward. He was able to disclose. He should have been able to proceed forward. in doing so and having him not participate in this, I fear that this is going to be a tainted proceeding and that either party, and I'm not speaking on the matters of the at issue, I think that either party may have the reasonable expectation of being able to have this thing delayed further through some type of appeal that could go all the way to the United States Supreme Court, because we're dealing with the United States constitutional right of the freedom to petition. I just want to disclose that this is an issue that I think could probably taint this proceeding, and I wish that we would have been able to address that at some point in time earlier so that we could have the participation of the full board, because I think that's what the intention was.
Administrative Attorney Yonit Wilburn, thank you, Mr. Hardy, for your comments. I think you're missing one key point here. You're saying that the petitions were denied. These petitions were filed 3 times. We have an open petition in front of us that has not been addressed, that is addressed to the full authority. So that is an interested party because that has not been denied yet by the hearing officer. There is a renewed petition to leave to intervene filed by Mr. Carson requesting the full authority hear this petition.
And that particular petition is not on the agenda item today. As noticed underneath the agenda item here, it says the application of Paradise. It is not that they're considering whether to grant or deny the PLTI. Because of that, because of the way this was agendized, he should not have had to abstain or not participate in this particular item. It should have been the full body that would have done that. That's my concern, is that people have the right to petition on items. As carefully looked at this particular item, Mr. Carson could have reasonably said, this isn't my issue. And so therefore I have the right to petition one of my public officials, which he did and undertook. And as disclosed by the commissioner said that they didn't discuss anything relative to the PLTI, that they were discussing this particular item. And I think that indicates that he has the right to petition under the First Amendment, his public official.
Ms. Cannell, do you have anything with regards to open meeting law and the fact that the petition was not put under the Paradise application?
Radhika Kunal for the record. So the question is, do we have any concern with the PLTI being on the agenda or not being on the agenda?
Sorry. Can we hear?
The question is, the full application was as the full application, the PLTI was included in the backup materials as,
Sorry.
can I finish my comment, Mr. Hardy, please? It was included that there was still an open petition to be addressed by the full authority, which was included in the backup materials. It was not included the fact that that open petition existed in the agenda item as the description of it. Are we allowed to hear that petition that was put forth as part of the application?
Well, I think in part you're getting to the point, which is if you couldn't rule on that PTLI, which you can't right now because it's not properly agendized, then any discussion regarding that PTLI would not conflict the individual board member from participating in this particular item.
Sounds like, are you asking if Chairman Horton could get back onto the panel? Is that your question?
I believe it would be important, and it would not only that, but it would probably relieve any potential appeal issues. I have no, again, I'm not going to speak to one way or another on this particular application. I actually just want it to be done. Okay. And so one way or another, we get some resolution on this. But my concern is that by excluding one of the commissioners, this is going to create an issue of appeal that I have serious concerns that I may have to join in that appeal, given my practice in the First Amendment rights and advising commissions and boards on how to proceed.
I'm understanding your concern as you would like for the chairman to get back onto the panel. And that is exclusively your zone. Would you recommend or would you advise your client to reconsider his motion, his recusal?
Chairman Hartung and I didn't speak about this. I advised him based on the law. He made the decision to recuse himself. Legally, the only way I can see forward on this is that there needs to be an explicit and full waiver from every single interested party in this case to allow the chairman to come back knowing full well that that waiver will exclude arguing this in a future case. Because there is a waiver to allow him back, it will not be allowed to be a reason to appeal this case, knowing full well what was happening. I understand what you're saying. But that is,
The Tarkanian, so there's only one party to this particular proceeding, and that would be the applicant, because there is no agendized item for the PLTI. So what I'm saying is, if you want to get a waiver, you don't get a waiver from the public. Under the Tarkanian case, they can't waive the public, because the most public, it would be a waiver, if you're seeking that, of the applicant for their participation. But even then, I still have an issue, because we have the right to petition our public officials under the First Amendment. And if they don't grant that waiver, if they say, no, we're not going to waive it, right? I still then have the right, because he doesn't participate, to appeal this issue on a First Amendment basis on my right to petition. See, it's more than just this case. This is an issue that I think needs to be addressed very clearly, is that we have the right, as long as we don't reform a quorum, as lawyers and as advocates for the industry, to be able to have discussions with those people who are serving as public officials. That's a broad statement, and it's true. We do have the right to do that. And that's one of my concerns, is that this may have an impact on that particular issue. And because it's in a public forum and it's happened, this is my forum to talk about that and or address the issue through the courts if necessary. Ms. Wilburn, if it's helpful for them to give informed consent, if you want to have a statement by Mr. Carson as to what that discussion was about, so they can hear both sides of that particular discussion for informed consent, that may be appropriate as well. I'll let you make that decision, as you are legal counsel, and I respect your opinion on it, but I'm just giving that as an option.
So this is Radhika Kunal again. Well, there are two concerns, as I understand. This could be a point of clarification. You are, Mr. Hardy, petitioning the commissioners or the board to reconsider or have the chair reconsider his recusal. And you're in support of that. You're arguing that the PLTIs are not on the agenda. Given the fact that the PLTIs, if they are PLTIs or if they're formatted as protests, I believe it goes with as a package with the application. So those need to be resolved prior to getting to your question on the second question. And then unless you are, I don't know who filed the PLTIs exactly, but if the parties either withdraw those PLTIs/protests, the chair has to rule on them. I believe my advice is first figure out like where we need to actually clarify what's active in front of the board agenda and then in front of the commission right now. And next is to, and as to the question of would the chair reconsider his decision to recuse himself, that's, I believe, between his attorney and the commissioner.
I would agree with you that it's between him and his attorney on how they decide to proceed. I just want to make sure that that we as council and we as the industry have the opportunity to petition under the First Amendment those people who are serving the industry. And we believe that we do so long as we don't have a contested issue. I agree that if the PLTI was on the agenda today, that then, and that was for a decision, that neither side of that would be able to come forward. That is not what's on the agenda today. What is on the agenda is a decision. And if this was misagendized, then we can correct that and put that on for another time. And you want to, and you can have him make a decision on that. The other thing is that these PLTIs had previously, a number of them had been previously ruled upon, as we heard from staff report. And so, these things can happen. I just believe that I'm very much an advocate for the Tarkanian rule, which says, let them vote, right? As long as they can disclose. And I want to see every one of them vote. I want to see open discussion. I think that's what the industry wants, is open discussion between everybody so we get a complete vote so that we can all have some relief on this thing and know one way or another how we're all going to move forward tomorrow. And that's kind of what we're looking at. And I just want to make sure that we have that for those, and protecting in the future my right to petition one of my public officials.
Mr. Hardy, I will address one thing, is that this was agendized for the full application of Paradise to be voted on. The petition to leave, for intervene, and protest, as they were stylized, they did say protest on them, are part of the full application. It's a subsidiary matter that goes along with the application. It was included in all the background information. Everybody has the background information. It is part and parcel with the application.
So generally, to become a party to a proceeding, you do what's called an intervener. And in this particular case, I believe there may have been an intervener process that was done or attempted to be done, and that way it's either denied or maybe pending. And I would agree with you, perhaps the intervener would at that point in time be prohibited because they've actually intervened in the process. The petition, I don't think does anything on that particular issue other than voice their protest or voice their opinion on a particular item, does not make them necessarily a party until their item is set to be heard. And that I don't think has happened at this point in time, as it's not been properly agendized.
I understand what you're saying, but as I was saying, because it is part of the backup material, because it is part and parcel of a full application, petition to leave, to intervene becomes part of the application process. This was agendized for the application of Paradise to be heard. This was put in its backup materials. PLTIs were denied twice on this matter, and that was all put into the backup material. They are then again asking, and this was denied by one hearing officer and a second hearing officer. They are now asking to come in under NAC 706.3995 for the full authority to hear this. And that is how it is coming in under the application, as part of the application, in order to proceed on the application.
So one thing that I would note is that under the Ethics Commission rules in this particular state, backup materials do not equate to what's on the agenda. The agenda is very important because that's what the public and individuals rely upon when they do that, and when they have any communication with their elected officials. And therefore, despite the fact that you can include many, many things inside of the backup materials, that does not necessarily put the public on notice or awareness, which is why it's so important and why we work so hard to put together agendas that are appropriate, so that way we can make sure that everybody is properly noticed as to what they can or cannot do based upon the agendized item. And so that point, I just want to make clear, is that simply having it in the backup materials, I don't believe eliminates the need or provides anybody with notice that the PLTI is going to be decided in this particular agenda item.
While Ms. Wolburn is conferring with her client, I'd like to make a comment. If these PLTIs are framed as a protest can be made oral during the hearing, during the agenda meeting. So I believe those don't need to be separately agendized. Because when you file an application and when the application is noticed to be considered in its entirety, protest can be heard. If you make an oral protest, and anybody, as a matter of fact, can make that today at this time. When the chair obviously allows that. So given that, with that set aside.
And one other comment on that as well is having advised boards and, oh, sorry, Yoni, go ahead. Apologies. So
I just want to complete one comment. It's interesting that this is coming up now because we had an application on our agenda in December at one of our public meetings. It was agendized for an application. That's all it was agendized for. Ms. Rushton came up asking to be inserted as a PLTI. It was heard. It was not separately agendized as a PLTI. The full matter was heard in front of the authority and she was granted intervener status. So it seems a little odd if she's going to argue against, or she hasn't yet, but I don't know, but you are. But it would seem a little bit odd to now say, in that instance, it was fine. I had my PLTI. It was here part of the application. It was not separately agendized. I was heard on the PLTI. I was granted intervener status and I was allowed to go forward. But there was no separate agendizing that there was a PLTI in combination with that application.
And having worked with multiple commissions and boards and having helped them put together agendas in the past, what normally happens or what we've done and other boards have done is they'll identify the docket in particular and then sorry, am I not close enough? Let me see if I can move it over here. Sorry. What would normally happen is if you're going to take multiple matters at the same time, what you do is you provide an individualized line that says, for example, the application, the PLTI is going to be 154, and then 155, 156. Each of them come, you take them as a consolidated matter and you make a decision on all of them. That way, the public, which who I care about here is the public, having fair notice of what they can or cannot discuss, is identified and says, these are all of the actions that are going to take place. We're properly on notice of this, and therefore we need to make sure to either do something or not do something in order to make sure that everybody has the opportunity to vote. Thank you.
Thank you for that clarification. I do understand it. I was just saying that this exact matter has happened in front of this commission before and no one had an issue with it. There was anyone saying that because it was not separately agendized, it wasn't part of the whole application. And I think, I don't have the minutes, but I think it was argued that it was proper to be handled because the application was there and this is part and parcel of the application.
This is an abstention issue and not that particular item. And I'm trying to work on the abstention side of this to say, I want everybody
I
to.
believe we are deviating from the agendized item to intervene. This is Radhika Kanal. Chair, would you like to take over from here and make it ruling?
Just give me a few minutes to confer with legal staff. So let's handle one item at a time. I want to address the issue directly to Paradise. Would you consider a waiver in this matter to bring Chairman Hartung back into the hearing?
We would consider a waiver, yes.
We're going to take a 5-minute recess to make contact with Chair Hartung.